So be active lah. Okay. That's one. What else? So whether you start or not, your practitioner, later you discuss with your practitioner. They might need to look at your course papers and give a suggestion, improvement, or whatever. And then when do you want to start? It's up to you, or discussion with your tutors. Okay. You can ask them for any question and also can refer it to me for any apa-apa je lah issues. Alright, so tu satu. Lepas tu later I'm going to give you assignment question soon. And then for your mini hearing on the injunction application, there'll be 35% if I'm not mistaken. We are going to follow our course outline. Our final is going to be 40%. Our mid-sem 15, so 55. So we have another 45, 10%, if I'm not mistaken, it's assignment of 15%. And then oral submission, and then written assignment. I told them written assignment is based on your course papers, not on your written argument lah, based on your course papers, or else you have a lot to do. Okay. So what else? So basically that's about the announcement. So we are moving on our discussion on this week topic. I'm going to share the content. Masa view dia macam ni? Okay. I'm going to share content. Mana ni? Nampak tak? Can you see?
Yes.
Nampak.
Yes.
Okay, I'm going to give the notes later. So basically this week we are going to do affidavits. You have done affidavits, right? So basically that give you apa orang kata the practical side on how to do your affidavit. So we are going to learn about form affidavit by 12 model deponents, by illiterate or blind person. What will happen if use of defective affidavit, content of affidavit, scandalous matters in affidavit, alteration in affidavit not to be sworn before solicitor of party, okay, filing, original of affidavit or copy, document annexed to affidavit and affidavit taking outside of Malaysia without proof of seal and the language of affidavit. Okay, these are the main cases that we are going to look, inclusive of the case of our Tan Sri Musa bin Dato' Hassan. So you know who is Tan Sri Musa now? He's our Usain Board of Directors. Okay, and this the main rules is order 41. Okay, order 41, rules of court 2012. So you can have a look at order 41 as well, side by side with you. Okay, open your order 41. Page, in order 41, lambat pula dia nak masuk ni. Okay, so affidavit, forms of affidavits, okay, so basically all is in this up to rule 13. Okay, these are the important rules and cases. Okay, so basically what is an affidavit? Is it the same with pleadings? What's the difference between affidavit and pleadings? Anybody? What is affidavit? The one that you do, you have done affidavit, right? So what is actually an affidavit? What is it? What's affidavit in Malay?
It's like
Affidavit.
a support
Affidavit.
Support
statement.
document.
Dia bukan, ia juga dia support document, but it actually is akuan bersumpah. Okay, it's a sworn statement. Okay, it's different from pleading. Okay, the pleadings will consist of what? Statement of claim, reply to statement of claim and defense, all that, those are pleading. So basically, affidavit is a sworn statement. You do the notice of application, you do it together with affidavit. Okay, that's how the mode of commencement of your action, not commencement, sort of a mode of application is not commencement. If you were to recall the modes of commencement of your legal action, how many modes do we have? Ingat tak? We have writ of summon. You file it together with what? Imran, you punya tu bising. Hari ni tak payah buka you punya speaker lah, you terpaksa berdiam sebab you punya speaker rosak lah hari ni. Orang lain selain daripada Imran. Sian Imran hari ni. Kena di-silentkan. Anybody?
Ada two modes, madam.
Apa dia mode dia?
First, originating summon, dia mesti couple with statement of claim. Itu untuk kalau tak ada dispute facts. Tapi kalau ada dispute facts, kita akan commence dengan writ of summon. Dia kena supply dengan affidavit, sworn statement.
Affidavit, sworn statement. Okay. So basically, writ of summon you akan pakai sekali dengan statement of claim, and another one is originating summon. Okay, and then in the middle you have this in between. During the interlocutory application, you will have this whatever application. This is among one of the application, that is contohnya that you have done before is injunction. So you file by way of notice of application. Okay. So the case to mention here, the case of Alfred Dunhill and Sunaptik, where Roski LJ he was of the view that the draftment of affidavit should not put into the mouth of intended deponent legal argument. So in your affidavit, you are not going to put legal argument. Okay. That's why when I told you, remember when we discussed about your affidavit, I asked you to do the summary in the notice of application that have legal basis, kan? But as for affidavit, okay, you must put the facts that is relevant as summarized in your notice of application to support your facts of the case for your notice of application or injunction punya application. That's why your facts must be concise to elaborate what the urgency of your injunction is all about, why you need that injunction. Okay, you have whatever that is within your knowledge. Okay, the next case is bank utama. So basically, affidavit is inadmissible for one of authorization. Okay, if the case is issues of one of authorization, you need authorization of the person confirming that affidavit. Okay, if he has no authorization, okay, he must be authorized to do the affidavit, to sworn before the affidavit. If in that case the court found that there was no reason for the affidavit not to be admissible because one of authorization, because in that case there was no issue of authorization. If it needs issue of authorization, you need to prove that you have authorization in the affidavit. Okay. So these are the things that you must have in your affidavit, namely the title of your action, okay, the deponent's name, address and occupation. You check back your affidavit, do you have the deponent's name, your address and occupation? Remember last time when you asked me this to state the background of you put there who is plaintiff, who's the defendant, background things. I asked you to strike that out and put that in the statement of claim, because in the affidavit what is important there is the name, address and occupation, not the facts of the plaintiff or the defendant. Okay, that is supposed to be in the statement of claim. And then the deponent is employed by a party to the action, is a party to the action, or is employed by a party to the action. Okay, and then it is to be expressed to in the first person. You are saying I, saya. By the way, what language are you writing the injunction? I forgot. I think most of you write in English, kan? Is it?
Malay.
Oh.
Malay?
Both.
Both. Okay, itulah among the issues yang I lupa nak cakap lah. Tak apalah, boleh je lah Malay or English. By right it should be in Malay lah. Unless for the higher course they might ask you in English. Okay, divided in numbered paragraph, and then make sure that if you state the dates, sum and numbers is in figures, not in words. And then it must be endorsed with a note showing on whose behalf it is filed. So kena tengok balik at your affidavit. Is it endorsed on whose behalf? Okay. So basically the affidavit must be signed by the deponent and the jurat. Okay, the jurat is in form 74. Must be completed and signed before whom it is sworn. The sworn part, we call it as a jurat. You can look at it at form 74. Okay, if you look at the form 74 in your rules of court, I think most of you have done it, so you know what a jurat look like. Unless for the defendant you haven't done it before. Okay, to an affidavit, see that before the commissioners of oath, that commissioners of oath part down there, so that is the jurat. All right, so it must be signed. And then there are some important cases that you must know. Rabi, how irregular, and all these cases. So and I mentioned just now, all the affidavit shall be expressed in first person, residence. All these are stated in order 41. Okay, rule 1. Okay, and then affidavit by 2 or more deponents is rule 2. Okay, by illiterate or blind person in rule 3. And use of defective affidavit. What will happen if the defective affidavit? So an affidavit with the leave of court may be filed or used in evidence, notwithstanding any irregularity in the form. Okay, so basically even if it's defective with leave of court, it can still be used. All right. In the case of Ravi Supia S and Timbalan Hariawan Dalam Negeri Malaysia and another, in this case the person administering the oath to satisfy, which require a person administering the oath to certify if the deponent is illiterate. So the court held that unless there is evidence to show that the deponent is literate in Bahasa Melayu or Bahasa Malaysia, or certificate under order 41 rule 3 is affixed to the affidavit, prima facie the affidavit to deponent shall not be used in evidence on the face of it. So this is one of the requirements previous requirement according to order 41 rule 3. This is the same with order order 41 rule 3 by illiterate or blind person. If that person is illiterate or blind, okay, the affidavit, he shall certify in the jurat that the affidavit was read in his presence, okay, to the deponent, and the deponent seemed perfectly to understand it, and then the deponent made his signature or mark in his presence, okay, and the affidavit shall not be used in evidence without a certificate. Okay, there must be a certificate, okay, unless the court is otherwise certified that it was read to and appeared to be perfectly understood by the deponent. Okay, that is the case of Rabi anak laki Supiah. In the case of how you think, okay, in this the case they are still talking about the jurat part. So basically, strict compliance of which is mandatory. Okay, so basically, the court held that such a departure from the format was not trivial, but instead a substantial deviation. Okay, the jurat used in the affidavit was invalid. Okay, the affidavit were defective and admissible. Okay, so the court stated that as a consequence, application without a supporting affidavit and thus should therefore. Can you still hear me? Hello, hello.
Yes.
So, because I see it's okay. Okay, so you're still with me?
Yes.
Yes.
Sebab I nampak dia bulat-bulat tu. Dia bulat-bulat. So macam dia proses. Ahmad Hazim ni dia punya gambar dia ni yang bulat-bulat ni.
Ya, gambar dia memang cantik, doktor.
Ingat kan dia loading lepas tu aku bercakap seorang. Okey.
Doktor. Doktor, saya memang dah tukar.
Tukar apa?
Tak, gambar tu memang tu gambar lama saya dah tukar semalam.
Gambar yang bulat-bulat tu macam roda je tu.
Tu saya tak tahu dah.
Ya, gambar you bulat-bulat tu I suspect I tengok I tak nampak full screen, I nampak benda tu pusing-pusing. So I thought I was talking alone and the line is bad. So I terkejut aku bercakap seorang je.
No. We are hearing you.
Okay. Alright, sebab gambar you tu memang mengelirukan. Sebab I buka full screen, I tak nampak semua. Okay, sekejap can you still see my content? Affidavit tu.
Yes, madam.
Yes, madam.
Okay. So basically, it must be noted that the court should take a liberal approach. Okay, in admitting irregular affidavit. Kalau tak, if your affidavit is not there, do you think your notice of application for injunction is good? So you will be not as good. So so you understand the importance of having a good and compliance with order 41, or else it can be strike out by the court. Faham tak kepentingan betulnya affidavit tu? Kalau tak, kalau you tak ikut procedure, it can be strike out. So bila strike out is as good as zero affidavit, so it will lead your application to be strike out. Okay. However, in some cases, the court will still admit affidavit that are defective. Okay, the court should take a liberal approach in the interest of justice in admitting irregular affidavit. Irregular, okay. The rules of court should not be in hindrance for any matters to be heard on merits. Okay, it must be heard on merits. Okay, or else it can be breach of constitutional guarantees. In the case of Perwira Affin Bank, among the issues was whether the jurat can be on the top of the page following the last page at the substantive affidavit. Okay, Chung Fort Yang said that in fact the juror should immediately follow the end of a substantive spillover of the last vermin of the deposition on the same page. You can refer to this Hamid, sorry. Yalah, Hamid Sultan book, okay, Janab's case. So in this case, where was I? Okay, in this case, the juror and the said affidavit in the circumstances was regular and related to the disposition. Okay, it must be noted here strict approach to the procedural requirement. You can defeat the substantive justice. Okay, so you see how important. On one hand, it is important for you to comply with the rules of affidavit. On the other hand, strict approach to procedural requirement can lead to defeating substantive justice. Okay, in the case of Perwira Affin Bank, there were some issues discussed whether newspaper report was a proper source of information. An advocate and solicitor can affirm an affidavit on behalf of the client. Okay, so the court held that without any supporting document or sources, newspaper reports are insufficient to conclusively establish the fact in dispute. So who are using newspaper report? Newspaper report, you must think. Okay, whether you can still use that to support your affidavit application. I think some of you use Facebook posting to support your source of information kan. So you need to rethink, okay, of your affidavit. Okay, and then advocate and solicitor, okay, should not be a percussionist of his client case. Okay, so basically you should not you should not be in a position to affirm an affidavit on behalf of your client. Okay, although actually in real case, some advocate and solicitor affirm affidavit on behalf of their client. Okay, in the case of Samsuri Wells and bin Abdullah, okay, in affirming affidavit which he has no knowledge. So basically when you affirm the affidavit, you must have the knowledge what you are affirming because it's a sworn statement by your knowledge. Okay, so in this case, the counsel affirming affidavit which he has no knowledge. Okay, so basically it is in contravention of order 41 despite the fact that he knows of the case, but he actually no real knowledge of the issue or facts of the case, so he should not be affirming the affidavit. In the case of Malayan Banking Berhad and Chartered Field Corporation Sdn Berhad, okay, whether a solicitor may depose an affidavit on behalf of litigant. So basically, Ramli B. Ali JC was of the view that there are actually no express provision. Okay, so basically that says that it cannot be accepted by the court. But the solicitor may depose an affidavit on behalf of the client provided facts deposed must not be contentious or disputed question of facts. Okay, these are the principles that I will author my slide. So in cases whereby advocate and solicitor can affirm affidavit, they must make sure that the facts are not contentious and must be from his knowledge. Okay, and the third one is solicitor must have been authorized by litigants to dispose the affidavit on his behalf. So those are basically the main requirement. How about hearsay evidence? You heard you want to apply for Mariba injunction, whereby you have hearsay evidence that he is going to go away with the money. Okay, those kind of thing. Okay, the court held that the hearsay evidence may be stated in the affidavit provided the affidavit is used in interlocutory proceedings and making sure that the source of information and ground stated. So if you want to use hearsay evidence, make sure source of information and ground stated. So after this lecture, what you need to do is, based on the principles, okay, look back at your affidavit and evaluate it yourself, okay, whether your affidavit is on the right track or might be struck out by the court. Okay, in the case of Re-JL Young Manufacturing Company Limited, where the affidavit not stating the source of information, so it was an irregular affidavit, so it was not admissible in either interlocutory or final application. There are some other cases as well. Re-JL Young, that I mentioned just now, Dynacast, okay. Dynacast is like the case of Re-JL Young. Okay, the court stressed that failure of the deponent to state the sources and grounds of his belief rendered the offending part of the affidavit valueless. Okay, so from this case that the court has the discretion to strike out the offending parts of the affidavit as opposed to the whole of affidavit. That is by the case of Dynacast. Okay, furthermore, in this case, the court stated that the court is unlikely to exercise its discretion in favor of a party where it amounts to an abuse of the process of the rules. Okay. Hari Singh and Sundaramal. Okay. He's saying about to the best of knowledge and belief. Okay, based on information and belief at the same time. So basically, and it is necessary for the opponent to state how much allegation is based on personal knowledge and how much is based on information and belief. That is by the case of Hari Singh and Abdul Halim bin Abdul Hanan. It was stressed that originating summons is not an interlocutory proceeding. It is among the modes of commencement of legal action. Okay. So a deponent of an affidavit may only swear an affidavit of fact that he can prove by his knowledge. Alright, in the case of Datuk Bandar Kuala Lumpur and Zain Azhari, the court of appeal took the view that hearsay evidence may not be admissible by way of affidavit if the deponent knowledge. Okay, so, however, to amount to a satisfactory affirmation, affidavit must be affirmed who has personal knowledge. Okay, if the deponent of a public decision maker, he must make a full and frank disclosure of the basis upon which he has arrived at his decision. Okay, that is in the administrative and the political position of that case. And in the case of mill elite jewelers, there's issues of exhibit containing Chinese characters. It must be translated into the national language. Okay, the court said that those exhibit cannot be admitted nor regarded as exhibit, so it must be translated into the Malaysian language. And the case of Millbank, okay, an act and investment, the court stated that where the application finally determines the rights of the parties, so the affidavit must only include the facts that is within which the deponent has personal knowledge. For undischarged bankrupt, it does not, and as in the case of Top Samuel Jaya, the court held that undischarged bankrupt does not lack legal competency to support and affirm an affidavit. Samsuri Welch, where the photograph may be admitted in evidence. Okay, in this case, the court held that it should be greatly discouraged. The use of photograph should be greatly discouraged because as photograph amount to hearsay evidence, thus inadmissible in evidence unless it is proved otherwise to the satisfaction of the court, because it will be unfair to the opposing party who would be unable to cross-examine the photographer on the photograph used. So because the judge will be adversely influenced by the photograph. Okay, let's look at the next case. THS Industry service of copy of affidavit which was undated and unsigned. Actually, when you look at this case, you like, oh, why is undated and signed? They are so unprofessional. This kind of thought will come into your mind. But actually, when it comes to practice, all sort of things can happen. Lawyers not attending court during the court hearing time, affidavit not dated, and unsigned. These are the things that can happen. Okay, so basically, in this case, the applicant contention that it was due to an oversight on their part, and then the undated copy was served. Okay, so the original had been filed in court was unimpeachable. So basically, these are among the issues of affidavit. Defective affidavit may be used with leave of court, that I mentioned just now, and the court may strike out affidavit that are scandalous, irrelevant, and oppressive. The case of Rosage and Rosage. Okay. The case of Standard Chartered Bank. Okay, in this case, affidavit that is not endorsed and not completely shut out from being used in any proceedings. So basically, they are saying that this affidavit is not endorsed. Okay, the objection is that it is an defective affidavit. So the court held that it was redundant. So basically, the party relying on the affidavit still has the avenue of seeking leave from the court for the use of the same. But before you have this kind of affidavit that is not endorsed or undated or unsigned, make sure you fulfill all the compliance. If you do not fulfill the affidavit requirement, what you need is the leave of the court. So basically, you're not really being shut out from being used in the court proceedings. Okay, that is the case of Standard Chartered Bank. And the case of Goh Un Chong alteration in the affidavit, it must be initial before it is sworn. Okay, that's the practice. In this case, the affidavit contain erasures which are not initial by the Commissioner of Oath cannot be read as that erasures or interlineation must be presumed to have been made after the affidavit was sworn. Affidavit must not be sworn before the solicitor of the party. So basically, you need to initial if you make any alteration in the affidavit. The same if you are doing any alteration to your pleadings before that. That's common sense and that's quite a practice. Okay. So basically, affidavit in support of application made by the person other than the applicant must state that he is authorized by the applicant to affirm the affidavit. Okay. And then affidavit taken outside Malaysia is, I don't put it in the slide yet, must be is admissible without proof of seal, provided that it is subscribed by seal or signature of a court, judge, notary public, or person having authority to administer of oath in a Commonwealth countries, or in case of any other country, seal or signature of consular of a Commonwealth countries. Okay. The case of Syarikat Islamiah and Bank Bumiputra Malaysia Berhad, Gun Cik Tuan. Okay, counsel referred to the English case. Okay, court had no jurisdiction to allow effective affidavit. The court had jurisdiction to allow defective affidavit. Okay, and then the defect thus could be cured. Okay. So there were defects in the affidavit. The court held that so the court held that the filing of the short supplementary affidavit to cure a minor defect did not prejudice the defendant, and the court accepted the affidavit. Okay, there are some defect and it was cured by the plaintiff, and then the defendant objected it, saying that it was filed for the purpose of delay and abuse of the process of court, and then the court held that there was did not prejudice the defendant, so the court still accept it. There are quite a number of other cases. I think that there are around 10 more cases. I don't put it in here. So I want to stop sharing. Have I stopped sharing or not? Where's my face? I can't see my own face. Ah!
Yes.
Tak dengar? Hello?
Doktor dah stop sharing dah.
Dah stop sharing kan? I cakap sebelum I stop sharing tu korang dengar tak?
Dengar.
Dengar,
doktor.
Cakap seorang lagi. Ya Allah.
Dengar doktor.
Okay, good. So basically, do you get all the principles of affidavit?
Yes.
Do you have any questions so far? We stop at that case. There are quite a number of other cases. Okay. Ada apa-apa soalan tak? So basically, affidavit in reply must reply specifically to allegations of facts made in the affidavit. Failure to reply specifically to allegations may be fatal. Do you got it? Do you get it? So for defender, when you want to do affidavit in reply, you must specifically reply to the allegation. You don't reply, fatal. So you'll be guide for defendant later when you do your affidavit in reply. The case is Alloy Automotive. I'm going to write it down later. So basically in this case, the court held that affidavit, those allegations not replied must have taken to have been accepted. So you see the consequences of not replying the specific allegations means you agree to that. The same with pleadings, remember? You must specifically rebut defense. You must specifically rebut for each and every item. Okay. And in the case of overseas investment, okay, the rule is clear. Material allegation not contradicted are deemed to be admitted. Okay. Next, court would only give due date to the allegation. Okay. So the mere fact that an allegation is relevant or not relevant or incidental, not being challenged by the other party, should not be straight away by the court to be truth. Okay, so basically the requirement is that somebody asked me. Okay, did anybody ask me about the affidavit in reply? Oh no, the days. I remember somebody asked me or it was other things. Okay, amendments to order 2, order 32. It is a strict requirement that affidavit filed in support an application must be filed and served on the other party within 14 days from the date of the filing. Okay. And the party wishing to reply to an affidavit served on him must file his affidavit and serve it within 14 days. So the 14 days rule apply in practice, but for your case, since we are running out of time and or if we were to comply really with the 14 days rule, we are going to be running out of time. You are taking a long time. No, you like to take the time. Okay, but we waive that during our class, but that's the rule. The rule is stated in Order 32, Rule 13 sub 2. Kita tengok Order 32, Rule 13 sub 2. So basically affidavit shall be filed on served the derivative within the 14 days from the date of filing of the application. Macam ada orang tanya lah. Lepas tu I was in passing macam kita dalam kelas tak payahlah kan observe the 14 days. But as a matter of practice, the 14 days rule apply. Okay. So the court has discretion whether to allow or not to allow cross-examination of the deponent on the affidavit. And then there's this case of Chu Kim San. Okay, cross-examine. Okay, it's not in our syllabus about cross-examining. So basically, it's up to the discretion of the court. Okay. What else? Cross-examine. There's thing authority. Okay, in the case of Syarikat Ying Mui Sendian Berhad, on the issue whether authority is a prerequisite to swearing in okay, the requirement for the person to be duly authorized to affirm. Last time, during my earlier lecture, I talked about one of authorization. Okay, those are among the issue. Okay, and then order, they're still talking about cross-examination of affidavit. So basically, in the case of Tirumenia, anak lelaki Singgara Velu. Okay, so basically, about who should be the deponent of affidavit in originating summons as well as to reply to it may at times become technical as well as substantive. Technical and substantive. In this case, in this case, the Court of Appeal held that Order 28, Rule 3 by itself does not impose the same restriction in respect of affidavit in reply by the defendant. If it filed by any other person authorized by or of the defendant who does not have personal knowledge, may not have probative force. So basically, they are not talking about authorization, but about personal knowledge or not of the affidavit, because basically when you want to affirm an affidavit, you must have personal knowledge of what you are affirming. Siapa pernah buat sumpah? Bukan sumpah kat Al-Quran tu, sumpah dekat Suruhjaya Sumpah. Ada tak? Agreement Muslim kan? Scholarship kan? Aduh.
Azim.
Agreement Muslim kan? Okay. So what else? We have talked about the form of affidavit. I'm looking at the Order 41, making sure that we have touched on each and every part of it. Affidavit by two or more deponents. Okay, name of the persons shall be inserted in the jurat, except if the affidavit is sworn by at the same time, at one time before the same person is sufficient by all or the above named deponents. Okay. Different languages, there'll be a separate jurat shown in the each language. If it's illiterate, so there must be this jurat certifying that it has been read into his present. Defective, it can still be used. Order 41, Rule 4. Contents, so basically contents of affidavit that I mentioned just now. Rule 5, affidavit, it may contain statement on information or belief within the sources and grounds thereof. That is Rule 2. Okay, Rule 1 says that facts the deponent who is able in his own knowledge to prove. Scandalous matter, Rule 6. Court may order to strike out any affidavit which is scandalous, irrelevant or oppressive. That is Rule 6. Alteration. Okay, it shall not be filed without the leave of court unless the person has initialed it. You must initial it or else it cannot be used. Okay, initial it and then that is under Rule 7. Okay, affidavit not to be sworn before solicitor or party and a member of that solicitor. An affidavit is not sufficient is sworn before the solicitor of the party. Okay, filing of affidavit shall be filed in the registry. Alright, use of original affidavit on office copy. Original affidavit may not be used unless it has been stamped with the appropriate fee. Okay, that is Rule 10. Affidavit has been filed, an office copy may be used in any proceedings. That is with regard to evidence lah. Have you done evidence by third year or fourth year? When did you do evidence?
Fourth year.
Last semester.
Okay. Okay, document annexed to affidavit. Okay, shall be exhibited. The copy annex, you have a lot of exhibit. Some of you got like 40 pages inclusive of exhibits, right, in your affidavit. Okay, and then shall be identified by a certificate. Okay, certificate of exhibit. Did you do the certificate of exhibit? Ah,
Yes, madam.
okay. Yeah. Okay, affidavit without proof of seal, that is order 12 and language of affidavit. Okay, a form outside jurisdiction may be filed in English. Okay, and need not be accompanied by international language. Okay, so we have covered order 41, the important points in Janab's book. Any questions?
Saya ada.
Ah,
Saya ada soalan.
ya, siapa saya tu?
Atika.
Atika.
Madam, kan kalau affidavit tu tak clear semua kan dia boleh struck out by the court kan? Tapi kalau mengikut order 41 rule 4 tu, dia kata kalau leave court boleh digunakan sebagai evidence. Macam mana tu madam? Adakah dia contradict each other or not?
Tak, dia tak contradict each other. Actually dia banyak kepada discretion of the court sebab it's a procedural tau Atika. Dia as a matter of procedure. Rule of court ni dia rules. Tengok ni. Rules of court. Lepas tu dia rules of procedure. Ingat tak masa awal-awal kita belajar yang compliance ke non-compliance tu. Dia kata courts, walaupun as much as possible kita adhere to the rules tapi banyak cases juga yang walaupun tak comply it still can be used. Tak boleh be used but with the leave of court Atika. Dia dapat kebenaran mahkamah. Maksudnya dia kena minta kebenaran mahkamah untuk masih menggunakan defective affidavit. Dia tak boleh guna as of right lah. Dia kena minta kebenaran mahkamah. Tapi tu satu. Defective, we are talking about defective affidavit. Yang satu lagi tu bukan defective tau. Yang satu lagi scandalous, apa tadi? Oppressive and irrelevant kan? That is another rule. Rule berapa tu? Dah tutup pula. Scandalous, oppressive and rule berapa tu?
Rule 6 madam.
Okay, rule 6. Itu kalau scandalous, oppressive and irrelevant. Dalam tu dia adalah perkara yang lain. Itu bukan defektif. Itu kan maksudnya yang scandalous yang you cakap tu. So they don't contradict each other.
Okay, nampak perbezaannya madam. Okay, thank you madam.
Okay. Ni kan bagi contoh kan, dulu kan. Cerita lama lah dulu masa Anwar Ibrahim kena tangkap tahun 98. 98? Itu yang baru lah. Tak ingat lah banyak kali dia kena tangkap lah kan. So basically, I rasa tahun 98. So basically, Wan Aziza, dia file an affidavit application to the court. Dia kata, dia takut masa tu geng-geng Tuan Mahathir akan cucuk. Dalam affidavit tu dia ada cakap dia takut geng Mahathir akan cucuk HIV punya injection dekat dalam tu. So ada I tak baca betul-betul lagi tapi there was issues lah saying that part is like scandalous or irrelevant or oppressive lah to the government during that time. So I tak ingat sama ada the whole of affidavit was strike out ataupun bahagian tu je. The application, I rasa application apa masa tu? Puan Aziza dia nak keluarkan Anwar daripada penjara lah. Ada one of those application that I don't remember. So that kind of contoh, that is scandalous. Kalau defektif tu apa tau? Tak sign, tak cot, lepas tu ada benda-benda content dalam tu bercampur-campur fakta dengan law ke apa, that can be defective as well. Okay, so what you can do is based on this lecture, you tengok balik you punya tu, ingat tak ada certain group tu I cakap macam tak ada apa-apa je dalam injunction application you all, macam tak cukup fakta. So basically you cakap secara di situ saya nak minta injunction je tak cukup. You kena cakap bila dalam notice of application tu you kena cakap grounds, summarize of grounds. You kena tulis kat situ. Boleh ada legal sikit tapi dalam affidavit is more on facts. So maksudnya you boleh goreng facts yang tu based on your belief. Tapi kalau hearsay kan, kalau hearsay evidence tu you kena ada apa cakap belief and source of information and grounds lah. Okay. Alright. So Facebook posting ke apa ke, you all kena ni lah. Kena argue lah whether that can be used or not. Alright. Nak break ke apa ni nak habiskan ni? Anthem pillar. Nak break 5 minutes ke before we proceed? Nak terus je? Hello, are you there? Adakah anda di sana ataukah anda sudah
Terus.
Terus.
Terus madam.
Okay. Share of content. Ni ke? Salah pula aku bukan ke? Macam tadi. Yang ni pula. Mana? Okay. So ni sikit je lah. I pun rasa dia nak pengsan dia ni. Anthem pillar order. Last time we do Marifa injunction kan. So this time round we are going to do anthem pillar order, jurisdiction, procedure and condition and set it aside. Okay, these are cases campur dengan yang sebelum ni lah Marifa. So for anthem pillar, Lien Kiao and anthem pillar case itself. Okay, there are 4 types of injunction. Previously we did Marifa at interim injunction. After we do anthem pillar, I'm going to touch on ad interim and ad infert. But for an anthem pillar injunction, so basically it deals with problem of piracy, modern day pirates of books, record, copyrights and trademark violations. Bukan Pirates of Caribbean tau, ni pirate. Lanon cetak rompak. Okay, piracy of books, films and records. Okay,
Madam.
So
Madam tunjuk slide affidavits ke?
Alah, dia tak tu ke? Patutlah cerita kat seorang. Ya, so I kena stop. I dah pergi anthem pillar. Sekejap. Ni, nampak? Nampak yang terpilih tak?
Belum.
Belum sampai.
Gapo dia tak nampak? Aduh. Cakap sok-sok sendiri ni. Jap-jap Patutlah macam di awan lalu je. Kejap-jap. Share content. Oh, I belum tekan lagi. Ya Allah. Nampak tak? Nampak ke?
Belum.
Belum.
Tak nampak, madam.
Ya.
Aduh. Okay. Ha. Asal dia macam tak boleh pi. Aduh. Jap. Okay. Ha. Share content. Okay. Okay, PowerPoint. Oh, dia ni lah. Aduh, ni lain ni. Not this one. Asal dia tak share benda yang I nak share? Tak nampak Kapo dia ya.
Okey. Putih.
Dengar? Patutlah bad quality network. Okay, sekejap. I tekan lagi. Try lagi. Aduh. Dia tak mau pi. I tekan dia tak bergerak. Dengar tak?
Dengar doktor?
Dengar je. Tapi asal I ni tak keluar apa-apa ni?
Sekarang pun tak keluar lagi.
Tak keluar.
I rasa sama dengan korang macam kelas hari tu group semalam kan? Group 7-8 kan semalam. Tak keluar apa-apa kan?
Ya.
I rasa ni lah sebab line. Okay, I cakap je lah korang. I tunjuklah muka I. Nampak ke muka I? Ke kau nampak slide ke?
Nampak madam.
Ish. Nampak spotlight. Apa maksud spotlighted ni? Oh, maksudnya highlighted. Okay. Aduh. I tak boleh keluar pula. Apalah. Okay. So basically deals with piracy. You have this joint venture agreement with other party and they pirated your books, your film and records. Okay. So basically in violation of intellectual property. So basically this is an ex parte type of injunction. It allows the plaintiff to enter a defendant's premise to search and seize evidence that may be used against the defendant in a civil suit. The case is Anthem-Pillar and manufacturing process. Later you can have a look at this case. So basically, okay, this is provided for in order 29, order 29 of rule 1 sub rule 2A. Okay, you can have a look at order 29. This is more or less like the last the normal injunction application. Okay, so basically you can have a look at this order 29. Okay. Yep. So in this case, hold on. Yeah, what? No, finish up your work first. What did you say? Finish up your work first. I finished homework and then time? No, finish up till 60. No, you said 40. Okay, some more. 60. Bye. Sorry. Kau tengok yang cerita IG story tu yang dia work from home macam ni lah. Tapi perempuan tu dia baling-baling benda kan ni. Tak boleh nak baling sebab budak besar. see we have class, and then this boy, he wants things. Okay, what I was talking about, anthem pillar. Okay, so procedure, two general requirements. One is speed, and the second one is secrecy. So that's why you apply it by way of ex parte. Legal requirements is that for basically the plaintiff must have extremely strong prima facie case, and then the damage to the plaintiff, whether actual or potential, must be very serious. Number three, clear evidence that the defendant has incriminating evidence in his possession. And then at the antebellum hearing, the plaintiff must show that there is a strong possibility that the defendant is going to keep the evidence. Again, the fourth is there's a real possibility that the defendant will destroy such material evidence before an inter partes applications can be heard or made. So this is why we need this antebellum order. So you can read it, the case of antebellum. So basically the guidelines laid down in the antebellum. Number one, plaintiff must be accompanied by his solicitor. Number two, the defendant must be given chance to discharge the injunction if they wish to. Number three, if the defendant refuses to let the plaintiff to enter the premise, then the plaintiff should not force himself to enter it. The plaintiff will have to apply to the court to determine whether there is an act of contempt of court on part of the defendant. The cases that are relevant, the Malaysian case that are relevant in the case of antebellum are Lian Kiao Stian Berhad. Hold on. Sorry. Tak dengar apa-apa kan?
Tak
Hello?
dengar, madam.
Okey, tak apa. Sebab I tengah menjerit kat anak I.
Takut.
Okey. Apa?
Takut, madam.
Dia dah kena grounded. Sebab dia main game, computer game sampai tengah malam. Lepas tu hari ni dia dah kena grounded lagi berani nak tanya. Nak main game ke tidak on his groundment day. Okay. Cases Lian Kiao. There I put that in my slide. Television broadcast and Arthur Anderson. In the case of Arthur Anderson, the court held that antebellum order was not granted because of two reasons. The plaintiff did not make a full and frank disclosure, included the discovery of the application granted to the plaintiff at the first place, and the defendant did not set out in its affidavit application in support of the consequences if the antebellum was not granted to the plaintiff. Okay, so basically in that case, antebellum was not granted. And in the case of Arjunan and Kesatuan Pekerja Ladang, okay, they allowed the discharge of the antebellum injunction because the material document were not kept exclusively by the defendant by a third party. So they have other recourse beside the third party by other parties as well. Okay, in this case, it was held that giving away the document to the plaintiff, the defendant would be incriminating themselves with the documents. Okay, enforcement of antebellum order. So basically, how do you enforce it? The plaintiff will go to the defendant premises. Okay, it depends whether the plaintiff has to ask permission to enter and search the defendant premise. Okay, the request is to be done during reasonable hours. Okay, if the defendant says he wants to seek legal advice, he has the right to do so. Okay, so basically there must be reasonable time given to the defendant to seek legal advice. Under the case of Bimji and Chatwani, okay, the defendant's lawyer and court officer will go together. Okay, it's not a search warrant, but defendant can refuse entry. If he refuses entry, the plaintiff can bring his refusal to the attention court, and court may make a ruling that it may cite it as an act of contempt of court order. Okay, so the plaintiff then bring the defendant's refusal to the court, and the court will decide whether its refusal is reasonable or not. Okay, if the defendant refusal is unreasonable, there will be two possible consequences. Defendant, contempt of court, he can be fined or imprisoned. Or is number two, if an adverse inference may be drawn against the defendant under Evidence Act for self-incriminating evidence. Okay. The court held that tracing order did not put the defendant in a position where they would be exposed to risk of criminal charge. So the defendant has actually, in that case, Arjunan has been charged for cheating and falsification of documents. So basically, these are important elements, okay, of anthem pillar. The first one is the facts or the requirement, the guidelines by the case of anthem pillar itself when it's used for copyright cases. The guidelines, as in the case of anthem pillar, the Malaysian cases, Liang Kiao, television broadcast, Etta Anderson, the procedure, okay, the requirements, okay, is unlike Mariva. Okay, it's quite specific, okay, extreme prima facie case. And then how you go about enforcing this anthem pillar injunction. And then how do you discharge an anthem pillar injunction. That's one question on anthem pillar kan, dekat dalam tutorial question. Perasan tak? Ke tak tahu tu anthem pillar? Ke tak baca tutorial question? Alu? Korang tak baca lah tu.
Yang practical week 1 tu doktor? Aha.
Ada tak? Perasan tak tu soalan anthem pillar ke blur? Apalah madam punya soalan ni, matilah mau jawab. Ingat ke? Tak ingat ke?
Perasan.
Okay. Apa?
7 hari tu ke?
7 hari Oh, okay. Nasib baik. Nasib betul. Okay, 7 hari lah. Okay, lagi ada types of injunction. Okay, apa lagi ya? To make sure that we have covered everything. Order 29. Erringford. Erringford ni injunction pending appeal of a decision to preserve the status quo. Dia macam state of proceeding application. Dia derived from the case of Erringford Properties. So basically, in the event that a judge has dismissed an ex parte injunction, he may grant an injunction pending an appeal of a decision. So pending an appeal of a decision, kita panggil dia Erringford injunction. It can be granted lah to the parties. Pending appeal, kalau pending appeal je, Erringford injunction is like a state of execution. Okay. Apa lagi? Test dia sama dengan interlocutory injunction. So basically there is a likelihood of a successful appeal being regarded negatory. Okay, so basically principle governing interlocutory injunction are equally applicable to the grant of Erringford injunction. Okay, it must be considered the overall justice and the case and whether damages are an adequate remedy. So Mariva we have covered. Lagi satu. Dah kan? Mariva, anthem pillar, I guess Fortuna. Have I mentioned Fortuna just now? Actually Fortuna in our syllabus, but as a matter of completion, so basically ni injunction applied to oppose the winding petition of the creditor. Ada belajar ni, winding, bankruptcy. Ada belajar bankruptcy or is it? Ada belajar bankruptcy? Ada?
Madam sudah belajar bankruptcy.
So ada belajar Fortuna injunction ke?
Macam tak ada. Tak pernah dengar.
I
Rasa
rasa
tak ada.
sebab ni maybe dia ni maybe satu Ya,
Doktor, ada diajar tapi tak menyeluruh.
adalah tu. So basically inilah, you know, because inilah satu practitioner side tu, satu academic punya discussion, satu kadang-kadang it can be different lah. Kadang-kadang yang kita ajar dalam buku ni as a matter of academic banyak, tapi bila when it comes to practice bendanya not as much as in the academic punya tu. Kadang-kadang yang certain benda yang banyak diajar dalam akademik dah tak pakai dah in terms of practice, macam tu lah. Okay, so maybe orang dah tak pakai. Actually when I buat injunction, lebih orang pakai orang redha je kot, kau nak kena winding up ni as a winding petition of the creditor. So I think we have covered injunction and affidavit. Done. Ada lagi soalan? Sekejap I buat nota comel sikit. Affidavit basically is already covered in your practical kan. So the teori tu I dah bagi. Saya bagi nota and I put down cases and some important facts there. So with the theory, you look back at your affidavit, making sense of whatever you are doing. Okay. Anything else? I guess.
Doktor, berkenaan dengan Anton Pillar Order, specifically on the issue of privilege against self-incrimination. So betul ke kalau pemahaman saya, Malaysian position dengan English position is different. Malaysian position at first dia ada isu berkenaan dengan common law apa semua, but then the latest position would be yang dia tak applicable. Kerana self-privilege, defense of privilege against self-incrimination tu tak applicable dalam case Anton Pillar Order Doktor?
Self-incrimination ni dia dalam apa, macam evidence ke?
Yes.
Self-incrimination Malaysia So basically, I see. Common law privilege against self-incrimination. Yalah, dia ada a different position because that is common law punya. Ni. So the issues is whether a person, common law kata we are not compelled to any questions that can incriminate ourselves. Tapi kita punya Evidence Act tu kata apa? Mana? Evidence Act pun dah mana hala. Ingat tak Evidence Act tu section berapa? Yang cakap pasal self incrimination. Okay, the privilege against self-incrimination 132. Okay, so basically, tapi the section does not expressly abrogated the ni. Ni more or less ni Syami, dia macam ni lah juga academic debate. Nah, just Evidence Act 132 Evidence Act 132 Ni more lebih ke arah ni, apa orang kata academic discussion. Academic debate lah. 132. Adalah paper yang discusskan pasal ni. On one hand, orang kata dia dah tak ada altogether. Okay. Witness will not excuse from answering on ground that answer will criminate. Konon ni macam clear kan? Okay, and in the upon ni. Tapi kan, that will expose him to ni, criminate tu, the criminal punya tu. Tapi there are other arguments yang kata the privilege has not been, dia ada argument kata privilege is not abrogated but still intact. Maksudnya Masih ada lagi. Dia punya argument based on. Sekejap apa dia punya ni? Apa? If matters under. Okay, dia kata in the case of ni. Ada case lah. Ni academic discussion lah. Dia more like ni. Ni I download ni. Artikel dah lama lah. Apa nama? Section 132 I
132.
masukkan dekat mana? I attach kat sini dapat ke? Masuk meeting notes ke? Macam mana I nak upload benda-benda tu yang I dah download tu? Meeting notes dapat tak? I masuk kat situ. Oh tak? Oh I pergi kat depan I pergi dekat depan. Okay. So I upload file You ada masa, you bacalah. Dia lebih ke arah academic discussion lah. Dia banyak ke arah academic discussion. Ada kata tak, ada kata ya lah. Which is not really procedural lah. Okay. Desktop, okay. Yang soalan-soalan hari tu I rasa macam dah jawab semua ke ada? I dah reply dekat dalam ni kan? Kat dalam group ke dekat dalam tu? Tu ada Syami, nampak tu? S132 I baru upload dekat files. You tengok dekat Teams punya genre files depan tu So basically ada yang kata dah abrogated langsung self-incriminating privilege. Ada yang kata tu still intact. So dia itulah I think the best person to answer kalau you nak tanya-tanya ni lah. Tanya Sir Muzaffar lah. Okay?
Okay, alright. Thank you, Doktor.
Alright. Okay, ada apa lagi tak? I rasa ada yang soalan-soalan yang you all tanya-tanya tu I dah jawab kan last week tu you all tanya-tanya tu. Lepas tu I belum jawab Did I yes or not? I tulis nota dekat situ Fatin kan? Sekejap I ada nota kan dekat si Fatin tu. Fatin Najihan ni suara dia pun tak dengar. Apa tu? Oh ni separate application, separate affidavit. Oh tu. Tapi dengan tu boleh tu. Mandatory dengan prohibitory, separate application, separate affidavit tapi didengar sekali. Okay. Saya adalah kot. Oh. Yang defendant tu dia reply to affidavit lah. Affidavit in reply of the ni. Okay. So ada apa lagi soalan? Tak ada. Ada? Tak ada. 5. Imran hari ni tak boleh bercakap. Patutlah dia punya mikrofon rosak. Patutlah senyap je. Aduh. Okay. So tak ada apa lagi soalan kan? So next week kita buat apa? Affidavit kita dah cover. Tajuk apa next week? Aduh, lupa.
Discovery.
Discovery lagi? Interrogatory kan? Interrogation apa benda?
Interrogatories.
1 minggu lah tu kan? Itulah all those procedures sebelum ni. Pre-trial lah apa benda semua tu. Okay. So I guess that's all kot. Tak ada apa lagi soalan kan? Okay, apa-apa.
Dengan practitioner nak buat apa je? Nanti dengan practitioner nak buat apa je?
You all, I bagi sama je tutorial question semua. Lepas tu ni, I ada bagi, you all dah cantikkan dokumen untuk buat mini hearing for the injunction punya application. Ni lah sebenarnya yang you all tanya ni. Ni yang practitioner tanya kat I suruh ni, I lupa nak beritahu Dengan practitioner tu nanti I will give one standard tutorial questions yang selalunya I letak case brief, bukan case briefing sangat lah, case discussion. I bagi list of cases, you do the discussion and then lepas tu I bagi problem and essay questions yang you buat outline, you discuss and then ada questions, practical questions yang macam yang minggu lepas ni kan kita buat drafting and injunction kan, and affidavit kan. So benda tu you all akan discuss dengan practitioner when you are ready to do the mini hearing and then you do. Boleh?
Yang soalan tu on the spot ke doktor? Masa tutorial lah.
Tak, tutorial I bagi sebelum tu lah sebab I nak kena bagi kau kat satu. Ya, macam tutorial yang ni I dah bagi dah, yang tutorial yang kita buat hari tu lah. Affidavit kan. Nanti I will give the tutorial question before we start. Tapi soalan tu I tak bagi soalan affidavit Okay lah, I bagi one simple question on affidavit tapi practical part affidavit you ada buat kan, nanti I'll do tutorial on affidavit. Before I bagi pada tutor and also to you to prepare lah. Okay, I bagi beforehand. And then kalau ada drafting tu you do drafting with them or do the question and answer problem questions lah. Alright, tapi sebenarnya I bagi dia orang ni ada benda yang tu general guide lah. Kadang-kadang dia nak buat lain ke up to them lah. Okay, tu general guide and then cuma ada benda yang kena assessment tu they need to do lah. Macam injunction application you will be assessed. Injunction application you will be assessed tau. 15 ke 20. 15 for oral submission and 20 for written. Written tu what I mean by written actually bukan written submission. I ambil you all punya yang course papers on the injunction application for your written marks. Boleh? Kalau tak kan banyak kerja korang. Takkan kau nak buat written submission pula on the injunction application kan? So I think taking your course papers, yang notice of application dengan affidavit will be good enough marks for your written part. Okay, benda tu maksudnya bila dah siap nanti you get ready tau for a mini hearing. Nanti I bagi rubric for ni evaluation. So you will have a course papers for written marks and then oral submission for oral punya markah. Boleh? So maksudnya semua orang kena bercakap lah dalam grup tu, you all kena bagi-bagi lah. Paling ramai berapa? 5 orang Kau ada point ada berapa je. Apa pandai lah kau orang dengan practitioner buat macam mana kan. Yang penting dia sebenarnya yang penting bukan kau orang nak menang tau. Dia yang penting lebih ke arah how you present your argument. Dia sebenarnya, I rasa sebenarnya tu lebih ke arah advocacy skill. Tapi kita nak tengok macam mana you buat, you translate your drafting notice of application and affidavit dalam bentuk court hearing, mini hearing lah. Boleh? You all ada advocacy juga ke this time?
Ada.
Advocacy dengan siapa?
Yusuf Farizal.
Lecturer, practitioner?
Practitioner. Untuk civil trial advocacy kan doktor?
So you are buat kes apa?
Macam ni doktor?
Ke belum buat lagi? Belum ada kelas lagi?
Dah ada kelas dah.
Kelas. So you are buat kes apa ke baru basic-basic je baru?
Baru basic, baru introductory.
So basically dia akan bagi you all buat hearing case apa ke tak tahu lagi?
Tak tahu lagi.
Okay. Itulah benda tu lebih ke arah advocacy. Yang mini hearing tu sebab I tak naklah buat yang susah-susah sangat, you know, or else you'll be like advocacy punya class. As long as it's you know how to present kan, macam mana nak present your case daripada drafted, you have discussed it with your members, you have do the drafting, discussion semua, you do that in court lah. So nampak macam in action lah, konon lah. Kat situ lah kau kena bambu dengan judge lah, habis lah. Itu satu. And then kalau you all perasan, my style is not really, I feel everybody do macam ni. Because this is a learning process, you kena cari in the sense that when you go through this ni, you will of course do mistake. Bila you do mistake and then I correct you, bila ada discussion kan, betulkan tu ni kan, katanya tak cukup lah injunction you. Actually that kalau kita ada LTC tu, that's what we are going to do kan. Tapi kita dah tak ada LTC ni, online manjang kan. So basically when I correct you, so that's your learning process lah. Kalau I bagi semua kat you, I dah bagi dah affidavit cantik dah. Tu pun kau dah dapat daripada sini kan. I bagi yang cantik punya notice of application. Nanti kau dah tak ingat, dah tak ada belajar apa. So basically you need to go through that learning process. Now the learning during the millennial age, so the lecturers, we give you the basic knowledge and then for you to grasp further on the point. So baca cases tu, and then we act like facilitator. Basically we facilitate. You go through the process, okay, the learning process, and then while going through it, you are going to learn a lot lah. Okay, daripada langsung you tak tahu apa-apa, macam mana ni? Macam dulu kan, last semester you learn how to do writ of summon and statement of claim, which you were clueless. You need to discuss the facts of the case, you baca dalam case, lepas tu you bina macam mana case you ada, that's your learning process lah. Okay, daripada I bagi you semua, tak belajar namanya, dia kena susah sikit sebab when you practice later, it will be more or less the same thing. Okay, although not sama, mungkin zaman I dulu lain, mungkin sekarang dia dah cara-cara dia dah lain, but it's more or less the same process that we have to go through in civil litigation. It's interesting, so you kena bertahan lah, and the real world out there is more challenging. Okay, but it's interesting. Alright, any question? Tak ada? Okay. Alright, so next week topik baru and your tutorial. Then going to give you assignment questions later. Okay, if that's all, we in our class we start speak kafaran suratul as. Ni recording ni kita boleh dapat dekat file depan ke nanti? Dekat general ke, dekat post ke, apa ke?
Boleh doktor.
Okay. Good.
Nanti
Macam
doktor,
last.
yes. Nanti doktor just stop the recording.
Okay. Entah siapa record ni, I merapu lah habis. Okay, that's all. Assalamualaikum.
Waalaikumsalam.
I pun tak